Hello everyone, welcome to lawminds. Today we are going to discuss about how to write a will. What is will? Will is a document written by a living person stating his or her wishes regarding the property and assets or to be executed accurately after his or her death. Will or testament means legal declaration of a person's wishes regarding the disposal of his or her property or estate after death. It is a written matter that specifies how your possessions are distributed after your demise and can designate guardians for young children. Every person wants to give his property to the legal heirs after his or her death. That is where will becomes essential. Will is defined under the Section 2H of the Indian Succession Act 1925 as will means the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. How to write a will? The will should be in a simple, clear, unambiguous language, so there should not be any confusion over intention of testator. Conditions are the writer should not be unsound mind, which means he must be conscious what he was signing a will that will be an impact. An individual must have the purpose to form a will when he or she decides to implement a permanent transfer of property after their death at the time of signing. The witness should not be beneficiary under the will. The person must be of legal age to make a will. Most states assume 18 to be the lawful age of permission. Procedure to write a will. First of all, you have to state your name, father's name, residential address, date of birth, etc. Mention who you want to be your executor and state that any previous codicils and wills are revoked. Next, list all your assets including properties, mutual funds, money in your savings accounts, fixed deposits, etc. Double check to make sure you don't miss anything. And next, transparently divide your assets stating who will inherit what to eliminate. Go item wise if you are leaving something to a minor. Mention who will be the custodian. Choose someone you trust. Then must be clearly mention the date of preparing your will. There must be two witnesses while writing will. Will must be signed by the writer and the witnesses for legal confirmation to be legitimate. In the case of joint property, a joint will is created and signed by two or more people, typically a married couple. It outlines the distribution of their assets and property in the events of their deaths. And now registration. After will was drafted, registering the same is a safe idea since you will receive a legal copy of the will this way. Moreover, in the case of tampering, the original will and the one submitted can be compared. Writing a will can even be done on plain paper without registration, or even a handwritten document can be termed as a will. Steps to be followed for the registration of will. First of all, consult a lawyer to draft the will correctly as per the details mentioned previously. Next, obtain an appointment for registration at the office of the sub-registrar. And then check your specific state's rules and then pay the registration fees required. Visit the office of the sub-registrar along with the two witnesses, and finally, in about a week, you can collect the registered copy. A writer or testator prefer to distribute asset to many persons like children, spouse, parents, brothers, sisters, or relatives and friends, and many people prefer giving something to charitable trust, welfare organizations too. Now, let's see the types of wills in India. Joint and reciprocal will, duplicate will, privileged will, holograph will, deathbed will, and concurrent will. Importance of writing will. Wills are necessary to avoid misunderstandings among the family members and select the eligible heir to asset once the owner dies. If a person passes away without making a valid will, disputes will likely occur among family members. However, religious specific laws are applicable in that case, but these can happen only if the dispute reaches a court. Creating a will speeds up property settlements and avoids property. And now, the acts that are deal with the transfer of property through will are as follows: the Indian Succession Act 1925, the Indian Registration Act 1908, the Indian Stamp Act 1899, and the Code of Civil Procedure 1908. Thank you.